Good morning, everyone. I'm going to wait just a few more moments to make sure everyone is able to connect fully to our Zoom platform.
Miss Kenzie?
Yes, Ms. Ainsley.
If you'll just give us a minute, I think on our end, we were having trouble connected. I think we had the wrong Zoom link. I'm just gonna turn my video off and make sure that Mr. Berliner has the correct Zoom link now.
No problem. We'll wait a few more moments.
Okay.
Thank you. And for those of you just joining us, we're just waiting a few more moments. I think we're all having a little slow on the technology this morning. So
I think on our end, we're all here.
okay, great. Thank you. And at this point, I don't see anyone else in the waiting room. I think everyone is connected, hopefully, who's planning to be here. So I'll go ahead and get started. Good morning. I'm Hearing Officer Nicole Kinsey with the Administrative Hearings Office of the State Water Resources Control Board. It is August 23rd, 2022, and this is a status conference on water right application 30166 filed by El Sur Ranch for a permit to appropriate water from the Big Sur River in Monterey County. I should correct that. I think technically it was filed by Mr. Hill. So note that for the record. This status conference is being conducted by Zoom web conference and is also being broadcast live on the AHO YouTube channel. Both the audio and video are being recorded, and we will post files of the recording to the AHO FTP site. The YouTube recording will also be available on the AHO YouTube webpage. If at any time you are experiencing technical difficulties, please send us an email to the AHO at adminhrgoffice@waterboards.ca.gov. AHO staff are monitoring that inbox, and they can let me know during the status conference that you're having trouble communicating with us. Assisting me today are several staff of the Administrative Hearings Office. We have Nicole Mullen, Amy Blunk, Skylar Anderson, and Kyle Wooldridge. At this point, I would like to move to appearances. To do that, I will identify each of the entities that filed NOIs. And if you are representing that party today, please unmute your microphone and state your name. I will take a moment to note that we have been updating our service list for this proceeding. And so if you haven't already, please take a look on the AHO FTP site. We do have updated service lists. We used an updated version for the most recent notice that we sent out. So please be aware that may continue to evolve as we work out some of these old contacts that we had from the prior proceeding. With that, as we proceed, if you would please keep your microphone muted, except when you're speaking. That helps with background noise. And I will first look to the applicant representing El Sur Ranch, or James J. Hill.
Good morning. This is Tom Berliner. I apologize for not being on the Zoom. I'm having connectivity problems. Took me a few tries to get in, and if I turn on the Zoom, the whole thing just crashes. So I seem to be doing okay with, as long as I took the video off.
That works fine for me. Thank you, Mr. Berliner. I understand. And please let me know, and Ms. Ainsley, please let me know if we have any trouble with the connection today. Thank you.
Thank you.
And Ms. Ainsley, I see you're also here. Is there anyone else representing the applicant who would like to introduce themselves? All right, with that, I will turn to California Sport Fishing Protection Alliance.
Good morning, Chris Schutz from the California Sport Fishing Protection Alliance.
Thank you. Good morning, Mr. Schutz. Do I have anyone from the Center for Biological Diversity? How about Ventana Wilderness Alliance? Trout Unlimited. And this one I'm going to do better. I can see already. Carmel River Steelhead Association. And you do have to go off mute, Mr. Linez.
Yes,
Thank you.
I realize that. Brian Leneve,
Good morning, Mr. Leneve. Thank you for joining us.
good morning.
California Department of Fish and Wildlife.
Good morning, Katie Miller with CDFW, joined with Nancy Murray.
Thank you. Good morning, Ms. Miller and Ms. Murray. California Department of Parks and Recreation. National Marine Fisheries Service.
Good morning. Good morning, Joel Casagrande, NOAA Fisheries.
Thank you. Good morning, Mr. Casagrande. And last on my list, I have Mr. Kirk Gayfill. I do not think this is the case, but is there anyone else on the call that I missed who plans on? I see someone just joined us. Ms. Tobias, would you like to introduce yourself this morning, I believe on behalf of California Departments of Parks and Recreation? Oh, did I lose her? We may have others with I wonder if it's Zoom.
This is Nancy Murray. I'm having trouble unmuting and I've never had that problem before. So I did get an email from Catherine that she's having trouble connecting. So hopefully she'll fix that. I just sent her the link again.
Thank you. And maybe a note, it might be a similar situation for Mr. Berliner and Ms. Tobias if stopping the video feed may help. But we'll take a moment. Ms. Tobias, if you're able to unmute and speak, and another option, if you continue to have problems, maybe hi. If it's possible to stop your video feed, that seems to be working for Mr. Berliner. We're having others with technical problems. I wonder.
I think I'm okay. I'm sorry. I had a lot of computer problems just now. So Catherine Tobias, Senior Counsel, California State Parks. And I apologize.
Oh,
So
no
sorry.
need. I understand. Thank you, Ms. Tobias. I'm glad you're joining us today. With that, I will turn again to the room. Is there anyone else who's joined us who did not have a chance to introduce themselves? All right, I thought I'd lay out an agenda for today. We have actually a number of things that I think will be helpful to talk about. First, I wanted to talk very briefly about the pending motion to strike from Elsa Ranch, and I realize there's been some briefing both ways on that. I just wanted to talk about the process for that. Second, I thought we'd move to the primary purpose of this status conference, at least in my mind, which is to address the inquiry from Mr. Berliner about how the applicant and other parties too might best communicate with State Water Board staff about application 30166 and amendments as those are being developed. So we'll discuss that. And then I would like to turn briefly to the mediation process that I laid out in the last status conference ruling that came out, I believe it was August 15th, and answer any questions to the extent I can and talk about next steps for that process. And then I wanted to touch on the deadlines I laid out in the status conference ruling of August 15th, which sets us up for our next status conference on September 8th. And then finally, I will of course ask if there's anything else we should address today rather than saving it for our next status conference, which is just about 2 weeks out. So that's what I see as the agenda. I'll get started. I first wanted to acknowledge that we do have an outstanding motion from Elsa Ranch. Their motion to strike the California Department of Parks and Rec memorandum appoints and to exclude participation of non-parties in this proceeding. I received a response to that motion from California Department of Parks and Recreation. And then I believe just this morning, if I read the heading properly, I received a reply on that motion from Elser Ranch. And so all of those will be available or are available on the AHO FTP site. My intent at this time is to address that motion in a written procedural ruling at some time in the future. What did occur to me, though, is I think it makes sense for me to wait to rule on that issue because there may be amendments to the application. There may be a change petition. I'm not sure. I don't think we've quite figured out the process of how those changes to the application will come in to the State Water Board and into the record. And there may be raised by this a question about renoticing and what portions, whether all or a portion of the application needs to be renoticed. And I think that may very well affect the question of party status and the scope of party status. So my inclination would be to wait on that motion until we see what kind of amendments to the application may be happening so that we don't have to address the issue twice. But I thought first I would turn to you, either Mr. Berliner or Ms. Ainsley, if you have any comments on waiting on that outstanding motion. It is your motion. And then I will turn to the other parties.
This is Tom Berliner. I think the process you laid out is fine at this point, but I do have one concern. These various pleadings and what we're going through take a lot of time, a lot of lawyer time. They cost the client money. And I'd like to just bring a halt to that so that if we could have some sort of understanding or an order from you, no more pleadings being submitted. I think both parties have had a chance to make their positions clear, and we don't know exactly the process, as you've indicated, as to how we're going to go about the amendment. But we'd like to limit very much the kind of work that we have to do on this thing, because really our focus is to get that everything finished so that when the hearing comes, we're ready and that the application can be submitted or whatever process we're going to ultimately agree to use to deal with that. So that's my request.
Thank you, Mr. Berliner. That I understand that, and I think I agree with you to the extent that if there are substantive arguments, and Ms. Tobias, I see your hand, so I certainly will turn to you, that there are substantive arguments about this application, those are appropriately made in an opening or a closing brief as we get to, if and when we get to a supplemental portion of the hearing. Ms. Tobias, please go ahead. I will turn to you next if you have comments on this.
I just wanted to say that we would actually like an opportunity to respond to their brief. We only got it this morning and I haven't even had a chance to read it. So I do agree that this process is a little bit unusual, but we're not only an adjacent property owner. The stream runs through our property. It affects the resources that we are a trustee agency for. So if Mr. Berliner would like to cut down his costs, then he can stop trying to oppose our participation. But otherwise, this is very important to state parks. And while I don't mean to make light of it, that's kind of a frustrating argument.
Thank you. I think I hear both sides of this. I mean, the party status and the participation is an important issue. I think at this time, what I'm going to, I don't know that I'm going to make a substantive ruling prohibiting, it's a little difficult to make a ruling prohibiting future motions that I haven't seen. However, I will just put out the caveat that I think the appropriate place for substantive arguments is not through procedural rulings at this time. There will be a time and place to raise all of those substantive arguments if and when we get to a supplemental hearing. And the reason I say if and when is it sounds like we may have opportunity for mediation and settlement. So there are different features of this process as we're going forward. And I certainly don't want to suggest that there isn't a chance for all the parties to come in together and have an agreement. So that's the reason for that. Ms. Ainsley, I see you have something to add. Please go ahead.
Well, I mean, I think that there are two issues at stake here. There are, and certainly Mr. Berliner can chime in to make sure I'm on message, but there are two issues. There are the issue of the broader participation of parties who were never participants in the original evidentiary hearing, for which this is a continuation. But then separately, our motion also addresses the issue of that filing of the memorandum of points, sort of unsolicited on the date of, I think, the last status conference. It was filed maybe that morning. And the fact that it was legal briefing that attached or cited to with hyperlinks, additional evidence that's outside the record. So I think we have two kind of separate concerns that you can address here. There's that unsolicited legal briefing and evidence that was that memorandum of points. And then separately, I can understand, as Mr. Berliner said, you wanting to think about, as this procedurally unrolls, how you want to deal with people who were non-participants to the evidentiary hearing. But I think that's a thing that we created by filing a sort of a motion that asked for two separate things. So I think that, to be clear, we want to also have a ruling on sort of the status. We want to make sure that evidence isn't just admitted into the record, or that legal briefing isn't just sort of washed into the record as a separate issue to the participation of non-parties.
Thank you, Ms. Ainsley. I think that's actually very, very helpful to me. You're right. I mean, I was aware that there were two issues, but you're right. They're somewhat, well, they are separate. I think the two can be addressed separately. What I would like to do is go back and take a look at the motion, and I will take a look at the briefings to see if I can appropriately address the first issue on this, at least providing further clarification if the memorandum of points, the memorandum that was filed by Parks and Recreation, whether it's a part of the record, whether it's stricken from the record, and if it is part of the record, what the status is and what the status. I will say evidence doesn't come into the record, into the hearing record, into the evidentiary record without going through the process of being offered and admitted. So, but I can provide clarification, and that certainly would be helpful for everyone. So let me take a look at that again. Thank you, Ms. Ainsley, and thank you, Mr. Berliner and Ms. Tobias. But I do plan at this point to likely not rule on the party status issue until the questions about how this application is going to be amended are a little more clear, because I think those are interrelated, and I don't want to do that part twice. Are there any other comments on this issue? We meet again in 2 weeks, so we can come back to it if we need to at that point. Thank you. I'll move to the next item, which is essentially the reason I called the status conference on fairly short notice, and I appreciate all of your attention to that. I did very much want to provide a timely response to Mr. Berliner and Ms. Ainsley and the applicant. I realize you're working hard to meet these deadlines that we are setting through this process, and I wanted to be available and respond and provide the input that you need, if we can, on developing the amendments to that application. Just by way of background for all of the parties who are on the line today, I described in my email of August 1st, which is on the AHO FTP site, and I CC'd the service list on that. But it's my understanding at this point that this office, the Administrative Hearings Office, will handle all of the additional proceedings in this matter. And that will include any supplemental hearing days, and it may include the development of a proposed order and a proposed permit, if that is the direction in which the proposed order goes, on application 30166, and submit that to the State Water Board. I think division staff may provide and likely will provide technical support to the AHO in developing any permit that would be associated with a proposed order, if one is associated with a proposed order. And the what we're working with is the prohibition against ex parte communications, which applies at this point to all staff of the AHO, as well as State Water Board members and all staff of the Division of Water Rights. So we're all on the same, within the same bubble at this point. So I think the best way to address technical or legal questions for the AHO or the division is either to do so in writing, in which all of the parties can be copied, or by discussion during a status conference in which all parties would have the opportunity to participate. I realize this is somewhat new ground for all of us as to how to do this. So we will have to work together cooperatively to make it possible. But I certainly think it's appropriate for the applicant, and I encourage the applicant to have questions and bring them to the AHO, and to the extent it's appropriate, I would be very happy to bring in technical support from the Division of Water Rights, someone who works on applications and can provide input if that is needed. And we can hopefully develop a way to do that within the boundaries within the boundaries that we have, where we can't have these ex parte communications. So with that, I thought I would turn to you, either Mr. Berliner or Ms. Ainsley. I think it would be helpful for me if you are able to describe the type of input that you're looking for from Water Board staff, and then we can have a general discussion. And certainly the other parties will have a chance to comment on this discussion about how we can do this in a way that's as efficient as possible. So either Mr. Berliner or Ms. Ainsley, I'm looking to you.
This is Tom again. So my concern is a practical one. There's a lot of engineering that's going on. The work's being done by Provost and Pritchard. Routinely, in this kind of a situation, there would be conversations between the Water Board engineers and the engineers that an applicant has working on any application. And with the reservoir being, a little bit, I don't want to say it's unusual, but making it a more complex application, there's a need for more conversation between the engineers. That's really what I'm seeking to preserve at this point, is the capability to just have routine engineering type conversations between the Water Board staff engineers and the engineers working for the applicant. Typically, those are not done on some sort of notice basis, and they tend to be phone calls. And hey, we're working on this. I got questions, etc. People here on the phone, I guess, know how this works. So, if we're going to do everything through the AHO, I think we need to have a practical way of keeping up the lines of communication. And I'd like to add one other concern, which is we got a request to prepare a draft supplemental EIR. And we had suggested somebody, and we got back that there needed to be an independent party. So some time ago, I sent in a note saying, okay, give me the list of companies that are acceptable to the Water Board, that if we contact them, that we can say they're on this list. We like to, we want to hire them to do the work. And I never got a response. So I need help with that as well. And I can tell you that the prior company that prepared the document for the Water Board was PBS&J, and they have been subsumed into AECOM. I don't know if those folks are still around or not. And I don't know if AECOM is an acceptable party to work with as far as the Water Board is concerned. They don't do any work for the applicant.
All right, let's see if, thank you. Let's see if we can work through, it sounds like two parts to this. The first part is this practical, the engineer to engineer discussions. I'm still a little unclear, and I participated in some of these, but obviously not the engineering to engineering discussions. As an attorney, I wouldn't necessarily be invited to these types of happenings at the State Water Board. I think I would be benefited if I understood what kinds of discussions they are. Are these discussions that can be had in writing? We can have a phone call in the sense we have a notice status conference. I don't see a way for us to have these types of discussions in a meaningful way, absent having a noticed occurrence or doing so in writing. even if I were to consider the possibility of asking the division for an engineer or staff consultant that would then be walled off and would be in isolation and wouldn't speak to the AHO and have any communications, I'm not sure that would do you any good, because then that person wouldn't be representing the opinions of anyone other than themselves. So I'm not sure, I'm still unclear as to what it is exactly that you're looking for in terms of these conversations, whether they're truly just technical, are we doing the engineering correctly? Although I would think that your consultant would be capable of doing the engineering correctly. I'm sure I'm missing something. Is there something, Mr. Berliner, that you can chime in and help me understand what it is we're?
Well, I can try.
Great.
I cannot give you off the top of my head an example of something that came up, but because I just didn't ask at the time.
Mhm.
But I did get a call some time ago from one of the engineers over at Provost and Pritchard, because I had sent out a note saying the ex-party rule is in place. And the engineer called me and said, well, gee, we've got questions we want to ask the water board's engineers related to the formulation of the application. And so it was the kind of thing that Provost and Pritchard is used to doing, and they typically do as a matter of course. And you know, I guess they all know each other and have these kinds of routine conversations when they're preparing applications. And so they wanted to talk to somebody and ask a couple of technical questions. So these are, I think, kind of, I don't know if generic is the right word, but they're specific to engineering work that would be done on an application that, as an attorney, I never participate in those calls. Frequently don't even know about them. And the engineers just go off and do their work, and they talk about it with each other. And typically the engineering staff is aware that this project is going to come in and what it's all about, because they've had conversations with the engineers that are preparing the work. So that's really what I'm after, is a convenient way to make that happen. And I just, I suppose we could try it, putting everything in writing and noticing everybody. But I mean, I think we could be adding months to this whole process of getting an application finished. And I'm really worried about a deadline being set by the AHO, water board, whatever, saying, hey, you got to have your application done in the next 90 days. And we have this difficult process to work with. And so we're anxious to get it done. And I see this as it making it more difficult. I mean, I'm not saying we're not willing to do it, but it just seems like it's tough to do if every time we have to notice something, go through the AHO, et cetera. If it would simply be a matter of preparing an email or a memo and copying everybody on it, that would be fine. And then if somebody had I don't even know, I was about to say if somebody had a concern, but I don't even know that that's something that should be open to debate. I mean, if our engineers have a question and the water board engineers have a question, it seems to me that needs to be between the applicant and the water board. There'll be ample time for people that have any concerns to step in and express those concerns, but we ought to at least be able to get through the process of preparing the documents.
Thank you, Mr. Berliner. I think it sounds to me like where we can start, at least this is going to be an evolving process and we're all along for the ride. So it sounds like where we can start is the process you just articulated, which is to start with an email copied to the service list that articulates particular questions. And it doesn't have to be particularly formal, but what's important to me is that the communication is copied to the service list and it's in writing. So it's in our record and everyone can see it. I think at that point, at least with the first ones, we can see what kinds of questions those are and whether they raise concerns for the other parties. I agree with, how do I want to say this? I am sensitive to your concern, Mr. Berliner, that I don't want to open this process up to what would essentially be a substantive evidentiary back and forth that is not in a formal hearing context. So I don't want to do that. That said, I do want to recognize that these conversations are going to happen on the record and with other parties having a full knowledge of what is discussed. But I don't want to start grappling with issues that haven't arisen yet. So I think this may be more easy to establish in the concrete once we have specific questions and see what kinds of engineering questions come up. If they're truly engineering questions and they're very specific, I suspect that this back and forth can occur and we won't have a problem, but we'll have to see. I do want to pause at this point and look to the other parties to this on the call today to see if you have any comments do you have any comments about this process for communication with AHO technical staff? I mean, this would primarily be, my understanding is these are conversations between the engineers for the applicant and scientists and engineers with the State Water Board, but these would be in writing, copy to the service list, and so available to all of you. Does anyone have any comments on that? I think what one of these, Mr. Schutz, I see your hand. Please go ahead.
So I'm sort of wondering whether the applicant agrees that separated staff would not meet its needs, and whether that's might be an avenue worth exploring. A lot of these sound like they're going to be questions back and forth more than specific, elaborated issues that get responded to in a similar kind of way. And it also sounds to me like some of these are the line between technical and how do you put something to technical issues and how you put something in a permit, or how you phrase it in a permit is not, it's necessary. It's something that engineers might do and that they often do. I've seen, in board meetings. On the other hand, it kind of moves into the realm of how you do something in a regulatory document. So I guess my question would be, is there a means for resolving these issues through separated staff that would not necessarily involve all of the parties? Not sure that that's the best answer, but I think it's one that would be worth an answer.
Yeah, we would not have an objection to that. I mean, and frankly, it seems like a reasonable approach. So, our point is to get the application ready to be submitted, however that ends up happening. So if there was staff that we could talk to that's separate from the AHO proceeding, that would be fine with us. I mean, I think under normal circumstances, that's kind of how it works anyway, not that there's necessarily a wall, but in this case, if some sort of walling off is appropriate, that's fine. As long as it's the appropriate staff that we can talk to.
That's helpful. I will turn to you, Ms. Miller. Please, you may comment.
Sure, thank you. I just wanted to voice support for Mr. Berliner's earlier suggestion that, CCing the service list on those communications is sufficient for our purposes. We would just like to be kept in the loop of the technical development, but not necessarily that we would be barging in as it goes on.
Thank you, Ms. Miller. That is also helpful. Would anyone else like to comment? I have a few more thoughts, but would anyone else like to comment before we move? Ms. Tobias.
That would be the same for state parks.
Thank you. I think what I will intend to do based on this conversation is I will look to, I'll have appropriate conversations about our process internally within the State Water Board and speak with the Division of Water Rights to ask frankly about the resource situation. Mike, one concern about well, there's two concerns about finding separate staff. I think in many ways it may be more convenient. One is a resource issue, is whether we can get someone, and then related to that is whether those resources can be provided in a timely manner. What I don't want to do is put us in a situation where we're waiting to move forward because this separated staff is, busy and they can't answer your questions in a timely manner. I mean, I suppose, so it's a conversation I need to have to the division. I think part of that would have to be that I would have the authority to put that separate staff on deadlines too, frankly. So that's a conversation I need to have. Fortunately, we're meeting again in 2 weeks, so I can come back to see if separate staff is a possibility. For now, I think if there are technical questions, Mr. Berliner, that come up in the interim, I would encourage you to use the method we talked about, which is email with the CC to the parties, and we can at least get moving. I don't want you to be waiting, if at all possible, while we sort these issues out. I will try to sort that out and streamline this process. If we're able to streamline it going forward, that's great. But let's operate right now on the presumption that we're going to deal with most of these in writing through an email. And as I said, it doesn't have to be particularly formal. And we'll see how that works. I mean, I know California has its own process, but there are other states that managed to figure this out. So I think we can do it. We'll see. Is there anything else for now, understanding that we will return to this issue at our next status conference? But is there anything else for now on the process for communication? So with that, I'll turn to the mediation question.
Oh, before we do that,
Yes, please.
sorry to interrupt, but
yeah.
Can we talk about the EIR
Oh, yes.
company, that whatever that is? I'm really just looking for the name of a company that would be acceptable to the water board. That I think that's all I need. And then I'm sure there's a normal process for bringing these folks on board.
Yes, one possibility is I can see if there is some list. I don't think the State Water Board endorses particular companies, but if there is some list of, I think we do have lists of consultants we've worked with in the past, and we make that available. So I can try to track down that list and make it available to you. The other possibility is you could send an email identifying a consultant and ask whether that consultant would be appropriate. I know you sent emails in the past, as you mentioned. Let's presume that since this matter has been reassigned to the AHO, the decision-making function is different. And so let's, if you would please ask again, to put it bluntly, because this all has been transferred over, as you know. That's why we're dealing with this issue. So it's in some ways a new chapter, and we will tackle these provisions again. I do want to get you going with whatever you need to do on your EIR. So let's add that. Can we add that to the list of things to be asked in writing to the AHO, and then we will follow up on that from there.
So just to be clear, you want me to send you a request for, well, first for the board's list, because I assume you keep a list of consultants that are deemed acceptable. I'm not looking for recommendation, just for the list.
I don't know that there's a list of deemed acceptable. I'm not sure that's something we do, but I can send you a list of consultants that I believe there is a list of consultants maintained by the State Water Board that have been used to develop EIRs that have then, for which the board has been a lead agency.
Okay, that'd be great. Yeah, I think that's really all we need at this point, and then just a question of their availability. So,
of course. And thank you. Thank you, Mr. Berliner, for bringing, I know this is new and we have to work through these pieces step by step, and I'm learning. So I appreciate your patience as we work through this. With that, I will now move to mediation unless there's something else we should talk about. So I mentioned in the most recent procedural ruling that I am able to offer the assistance of an AHO hearing officer for mediation. That would, for your consideration. I'm sure you can all, there aren't very many of us. So I will just say that the hearing officer would be Mr. Lilly, who does have, as I understand, training and some experience with mediation. So this would not be a first attempt on his part. If he does serve as a mediator, the process, as I understand it, would work this way. Mr. Lilly would be walled off. He would not discuss any confidential statements made or confidential documents submitted during the mediation process with me, with any members of the State Water Board or any staff of the State Water Board advising me or the board in this matter, unless we found some reason for Mr. Lilly to have a technical assist, in which case we may be able to find him another staff person who would then be within the walls of the mediation function, and all of those confidential rules would apply to that person as well. The mediation and all documents concerning it would be subject to evidence code sections 1115 and 1128, and would not be made a part of the administrative record for this proceeding. So they would not be public. If this is something that the parties think would be useful, I believe the first step in that process would be to articulate the specific mediation issues that I could then refer over to Mr. Lilly, and then he at that point would take over the process of the mediation itself and how those meetings would function. So I wanted to lay that out for you, see if you have any questions about how that might work, and then talk about if that does seem to be something that we think would be useful and worth the time, then I did lay out some deadlines related to mediation. That was sort of just to put them out there and get this thing moving. But I would like to hear from all of you about whether this process, if you have questions about the process or whether it makes sense. So first I'll look to the applicant, Mr. Berliner. I'll look to you first.
Sure. Well, we're amenable to a mediation process, and we understand the rules. So, you know, I guess our concern would be the timeliness and you know what process Mr. Lilly would see is taking place. How would the mediation be conducted? Who the participants are? You know, to my mind, it would be good because there is an extensive record to try to keep the need for preparation of documents to a minimum. Especially for those that have less resources. And, you know, if he wanted a sort of an opening brief or something, that would be perfectly fine. I probably would if I was the mediator. And so we're open, and we would be interested to know who else would be interested in participating.
Thank you. Thank you, Mr. Berliner, and I understand all of that. I guess I'll go ahead and just go through the list. I'll turn next to CDFW, just because you are sort of the main participant in the settlement agreement so far. So I will look to you first. Do you have any comments or thoughts about mediation, whether it would be appropriate, helpful, or any other comments?
The only comment we would have is to set some sort of time frame on that mediation, but the process makes sense, and we agree with how you laid that out.
And so if I can just follow up by time frame, so that a concern that mediation wouldn't drag on the process related to the processing of the application in general. And that let me step back. What I'm envisioning is that this mediation would occur within the timeframes and the deadlines that we are developing simultaneously through this hearing process. I want to give enough room for the mediation to take place, but that we would continue to move forward. Is that the type of timeliness that you were raising as a concern, Ms. Miller?
Correct, just that there's not a possibility of the mediation becoming endlessly open in terms of time. That makes sense.
Thank you, that makes sense. Mr. Schutz, I'll look to you next.
open to mediation, agree that it should be somewhat time bound. Not sure how it would work in the context of the regulatory process. I'm not sure how much bandwidth I and my colleagues have to do both, but we'll make our best effort to engage.
And let me clarify, I think, and I'm speaking on behalf of Mr. Lilly because I would give him pretty large leeway to work out the process. But as I understand it, the vision of this mediation would be, it would be a concise and efficient discussion. It would not drag on over many, many days of discussion, that this would be set up for the possibility of mediation and would be as efficient as possible, at least for the beginning foray into this. So I don't imagine this as a long drawn out process, and I don't think that would be appropriate here. But we need to, it also, that why I think it's important for us to articulate the specific issues, because it seems to me some of them are narrow, or the ones that have been identified so far are fairly narrow. With that, I'll just let me look to Ms. Tobias. I think I'd like to hear
We have no,
some recreation on this.
we have no objection to mediation.
And I don't mean to slight anyone, but I'll just look to the room. Is there anyone else who has any comments or concerns about mediation? I think this segues nicely into the last topic that I have for today, which is deadlines. I laid out some deadlines in the status conference ruling, including a deadline for the applicant to prepare an initial list of issues for mediation. I just wanted to get us started and get us moving. I also asked for the applicant to prepare a proposal for measurement and reporting and to confer with CDFW about that. Because of limited time, I just asked for the one conference before our next status conference, but leaving open that there may be further discussion during the status conference or afterwards. On both of those deadlines, I'll turn first to Mr. Berliner and Ms. Ainsley. Do you have any concerns about those, or do you need any further direction on what I was looking for, or anything else?
I thought the issues that we were going to deal with are the ones that were unresolved by the settlement agreement. So there are the two issues there. And there's some complexity into that, and I won't get into that. It does still strike me that the amount of time that the applicant is going to have to process the permit is one that really is not appropriate for the AHO. I mean, to me, it just seems like, and I'm not objecting to it, to me, it seems like an issue that ought to be capable of agreement between the applicant and CDFW to arrive at a reasonable amount of time that the applicant has the responsibility for completing whatever permitting work the applicant is going to have to do from the various agencies for which they will need to get permits. So is at least from the Water Board, from the Coastal Commission, and from Monterey County. And just by way of reminder, the proposal is that it be handled essentially like timed chess, so that when the ball is in the applicant's court, the clock is running. When the applicant has submitted whatever is being required, then the clock stops running and the agency takes over and does whatever it's going to do. And then when they get back to the applicant with something, the clock starts again. So that issue to me just seems like, I mean, I don't mean this to be derogatory, but I don't know that the HO brings any particular knowledge about this any more than anybody else. And it just doesn't seem like an issue that should be litigated. It seems like an issue that on a practical level should just get resolved. So it's our intention to try to make that happen without burdening this proceeding with that issue, but that's one of the two issues. And then the other issue concerns the bypass flow and to what level will pumping be allowed. And there's some technicalities associated with that that pertain to the ability of the ranch to pump at various levels and what the differential is between the impact of pumping from underflow versus impact on the surface water of the stream, because there's a culmination layer. And frankly, we've had some discussions about that to try to resolve that as well. And it just hasn't gotten resolved, but that's the other issue. And then I think on a non-evidentiary issue is the question of how to address the 1004 issue that was raised by the prior hearing officer in her analysis, and we indicated in a response to that we reserved our right to rebut what she was contending in there. And I think we'll look to the AHO for some guidance as to how to do that, whether that's appropriately something that gets addressed in front of the water board or whether that's something that can get handled here. And I would just observe that the terms of the settlement agreement at this point do dispose of that issue, because we agreed on more water being available than would be available under 2.5 acre feet per acre.
So maybe Mr. Berliner, if you would clarify for me, I think it sounded like on the first issue, the timing for permits. Do I have the timing for the applicant to, I may not be articulating it right. It almost doesn't matter. But is it your proposal that that issue be included in the issues referred for mediation or not be included?
Oh, if we're going to go to mediation, I think it absolutely ought to be included.
Okay.
Yeah, definitely.
It's just with the caveat that it may not ultimately be an issue that is something the AHO would address in any proposed order or something like that, which.
Well, I think there'll be a need, if we can't settle it among ourselves, then yeah, we would probably want to get some sort of order just for efficiency, and to resolve the issue. But I'm really hoping we can just resolve it among ourselves.
I see. So it sounds like you have a good handle, and I didn't mean by asking the applicant for a list of the mediation issues, I didn't mean to suggest they're any more complicated than what you've already laid out. I just wanted to have a very clear identification in the record of what those issues are proposed to be. And so it may just be you literally cut and paste them from some other document you've already created and send them back to us, and that's fine. I just wanted to be clear on the record.
Yeah, and that, by the way, is in the record. When we had the status conference some time ago, before Ms. Dodek left the water board, one of the documents that was submitted was the marked up settlement document that in section 6 of it lays out the open issues. And it's these two issues that are laid out there.
Thank you. And just for all the parties, that document is in our administrative record on our AHO FTP site. So it is there. Do you have it? Maybe I'll look, Mr. Berliner or Ms. Ainsley, do you have an approximate date? Was that was 2019, if I recall correctly?
Yeah, it was pre-COVID. Yeah.
I do have a date. It's in some recent briefing papers. I want to say
I am thinking April 2000,
okay.
something like that.
That does ring a bell. I'm
Yeah.
looking at something we wrote
Yeah,
in
I
here.
thought it was March 2019, but I could be wrong on that.
We're in there. I just wanted to give
I
it.
have April 15th, so
April
tax
15th.
day, 2019.
Okay, tax date, April 15th, 2019, and I'm just putting this on for all the parties' benefits so you can find that document in the record, but it is available there.
It is also on the Elsa Ranch proceeding website for the whole of the previous proceeding before referral to the AHO. The docket is there with that on there as well.
Yes.
So
thank
it
you.
might be a little easier to find than the FTP, and those links are live.
Yes. Good. And before I turn to you, Mr. Schutz, I will just ask to close out. Mr. Berliner, are you, do you have any other concerns about the deadlines in the status conference ruling for at least some initial proposals related to the measurement and reporting, and then also the mediation issues?
I think I've expressed what my concerns were about the mediation issues.
Okay.
On the measurement and reporting, I guess my question is more of a what is desired in terms of measurement and reporting?
And I think that is exactly why I suggested you confer with CDFW. That would be, so I would recommend to you to confer with them about what they're looking for. As I recall, it was either Ms. Murray or Ms. Miller who raised the issue. And I would want to hear from other parties on this, but because of the short deadline, I wanted my direction there was to confer with one another and come up with at least an initial proposal, if possible, before our next meeting.
And
Does
we
that-
can do that, I think.
Okay. With that, I will first, I know Mr. Schutz, I still have you on my queue, but I'll turn first to Ms. Miller and then to you, Mr. Schutz.
Yeah, thank you. I just wanted to say that in terms of who the ranch can reach out to within CDFW to discuss the reporting measurement, that would be Julie Vance, our regional manager in Region 4, and we can start those discussions. Otherwise, I would say that I think we disagree that there's strictly two mediation issues, but it looks like, I agree with the process you've laid out here, that the applicant will propose what the mediation issues are as they see them, and that then they will meet and confer with other parties and discuss if there are other ones out there.
Thank you, Ms. Miller. I appreciate both of those comments. Mr. Schutz, I will turn to you.
Sorry, I was just going to say that I did do the treasure hunt for that document the last time prior to this meeting, and didn't find it, and I will make an effort to find it again. I think it's important that we're all looking at the same document and making comments or decisions based on that. So I'll have a look again if I can.
Please have a look again. And Mr. Schutz, I believe the reason it may be a treasure hunt, if I remember finding it on it may be more clear on the Elsa Ranch webpage, on the State Water Board's webpage. However,
Okay.
When I found it on the AHO FTP site, I believe it's attached to the status conference statement, if I remember right. So it may not be a
Okay.
separate document.
All right. Very good. That would be helpful.
It may
And
end up separate. I mean, now that I could go back and separate it out and post it it might be helpful for everyone to post it as a separate document. So I'll take a look at that too.
sure. Thank you.
I do see it on the Elsa Ranch preceding the sort of the docket page for April 15th, 2019. It is titled, if it helps, Joint Hearing Management Conference Statement and Hearing Management Plan submitted by Elsa Ranch and California Department of Fish and Wildlife. And if you can't find it, Mr. Schutz, I'm happy to obviously flip anyone a copy if it just makes things faster for people.
Thank you.
Thank you. Thank you to all of you. Are there any other comments? I'll just look to the room. Any other comments on the deadlines coming up really for the applicant on an initial proposal for measurement and reporting, an initial list of issues for mediation? We will, of course, talk more about these the next time we meet. And so this is not the last chance, but does anyone else have any comments on that?
This is Chris again. I would have a similar comment to Ms. Miller, and that is, I'm not sure how one might end up parsing the different issues or how many there might be when you parse them. But I look forward to the opportunity to talk with the ranch and then provide additional issues if necessary under the schedule you laid out.
Thank you, Mr. Schutz. I will look and see if there's anyone else and also make the call. Are there any other procedural issues that we should address today, keeping in mind that we will be meeting again in about 2 weeks? look to the room for a last call just for today, if you will. So to close this out, I think I have a couple of items on my to-do list. I know the applicant has a couple of items. I appreciate all of you meeting on short notice. I think this was actually very productive and helpful to move us forward. So thank you again. We have already issued the notice for our status conference on September 8th, and I will plan to see all of you then. Thank you very much.
Thank you.
Thank you.